Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study case law number 27 about the case of acceptance and settlement of administrative cases related to real estate managed and arranged by the state in the course of implementing the housing management policy and socialist renovation policy before July 1, 1991. Including four-part, Part 1, Source of the Case Law, Part 2, Overview of the Case Law, Part 3, Content of the Case, Part 4, Assessment of the Court, Part 5, Rules. This law was approved by the Council of Judges of the Supreme People's Court on August 22, 2019 and published under Decision Number 293/QDCA of the Chief Justice of the Supreme People's Court on September 9, 2019. Part 1. Source of the Case Law. Cassation Decision Number 03/2018/HCGDT of the Council of Judges of the Supreme People's Court on July 16, 2018 on the case of suing the decision to settle complaints in Tra Vinh Province between the petitioner Mrs. Hong T.L. and the defendant, the chairman of Tra Vinh People's Committee. Part 2. Overview of the Case Law. Situation of the Case Law. The petitioner sued an administrative decision on not accepting the reclaim of the land use right and house managed and arranged to use by the state during the implementation of policies on land management and communal socialist renovation related to housing before July 1, 1991 according to the provisions of the National Assembly's Resolution Number 23/2003/QH11 dated November 26, 2003, which was issued with the suitable competence and procedures. Legal solution. In this case, the court had to accept the petition to resolve to aim at rejecting the petition. Key words of the case law. Key words of the case law. Administrative decision, decision to settle complaints, houses and lands managed or arranged by the state for use, policies on land management and communal socialist renovation related to housing before July 1, 1991, Part 3. Content of the case. The house located on number 05N, Group 3, Ward 2, T City, Tra Vinh Province was owned by Mr. Hong Sa R and Ms. Tram Tien, Ms. Hong TL's parents. This house was bought from Ms. Nguyen TK in 1967 with the area of 505 square meters. In 1969, the house was divided into 13 bedrooms and named Phang Not Bedroom. In 1972, Ms. N and Mr. Hong Sa are built another row of three-story houses, 05 apartments, 15 rooms in the back with a construction land area of 77 square meters. On April 13, 1976, Mr. N was granted a business license number 548/TN/GP/DK by Long Province's Trade Department on renting bedrooms. In August 1978, Tra Vinh Food and Beverage Hotel Company managed and continued its bedroom business with the form that the landlord worked as a servant and received a monthly salary. On August 21, 1984, the People's Committee of Tra Vinh Town issued Decision No. 35/QD84 on the management of the entire Thang Not Bedroom at Road N, Ward 2, Town T, Tra Vinh Province owned by Mr. Hong Sa, which stated, now, managing the whole house and land of Thang Not Bedroom, N Street, Ward 2, T Town owned by Mr. Hong Sa, including the front and the back home fleet, leaving 03 ground rooms of the back home fleet for being used by Hong Sa. Due to the ineffective business activities, on July 28, 1985, the People's Committee of Tra Vinh Town issued Decision Number 59/QD85 on the allocation of the houses which stated, now hand the entire Thang Not Bedroom located on N Street, Ward 2, Town T over to the Industry Committee of Tra Vinh Town. In 1990, Tra Vinh Import-Export Company was dissolved, and Mr. Hong Sa are appropriated and used. In 1992, Mr. Hong Sa requested the authority to return the house to him. In 1993, he died. His children, included Ms. Hong TL, have continued to manage and use the house up to now. Ms. L requested to be recognized the ownership of the entire land and house mentioned above. On July 27, 2012, the chairman of Tra Vinh People's Committee issued the decision number 1350/QDUBND on the resolution of Ms. L's complaint, which stated, rejecting Ms. L's petition on legalizing the entire house at 05 N Street, Quarter 3, Ward 2, T City, Trao-Vinh Province. Ms. L is allowed to buy back the land use right and the house located on number 05 N Street in accordance with the provisions of Decree number 61 CP dated July 5, 1994 of the government. On August 13, 2012, Ms. L filed a lawsuit against the decision number 1350/QDUBND dated July 27, 2012 of the chairman of Trao-Vinh People's Committee. At the first instance administrative judgment number 02/2015/HCST dated January 26, 2015, the People's Court of Trao-Vinh Province decided, rejecting Ms. Hong T.L.'s petition on requesting the court to cancel the decision number 1350/QDUBND dated July 27, 2012 of the chairman of Trao-Vinh People's Committee. In addition, the first instance court also decided on the court fees and the right to appeal of the litigants. On January 31, 2015, Ms. Hong T.L. issued an appeal to the entire first instance court judgment. In the Appellate Administrative Judgment number 175/2016/HCPT dated November 25, 2016, the Collegial People's Court in Ho Chi Minh City decided, accepting Ms. L's appeal petition, amending the first instance judgment number 02/2015/HCST dated January 26, 2015 of the People's Court of Trao-Vinh Province, canceling the decision number 1350/QDUBND dated July 27, 2012 of the chairman of Trao-Vinh People's Committee on resolving the request of Ms. Hong T.L., born in 1964, living at 05 N, Group 3, Ward 2, City T, Trao-Vinh Province. Chairman of Trao-Vinh People's Committee is responsible for issuing another decision in accordance with the law. In addition, the appellate court decided on the court fee. On January 10, 2017, the People's Committee of Trao-Vinh Province issued the official letter number 121/UBNDNC to propose a review according to cassation procedures for the Administrative Appellate Judgment number 175/2016/HCPT dated November 25, 2016 of Collegial People's Court in Ho Chi Minh City. On February 23, 2018, the Chief Justice of the Supreme People's Court issued decision number 05/2018/KNHC appealing the Administrative Appellate Judgment number 175/2016/HCPT dated November 25, 2016 of the Collegial People's Court in Ho Chi Minh City, requesting the Council of Judges of the Supreme People's Court to conduct cassation review to aim at cancelling the Appellate Administrative Judgment number 175/2016/HCPT dated November 25, 2016 of the Collegial People's Court in Ho Chi Minh City and upholding the first instance administrative judgment number 02/2015/HCST dated January 26, 2015 of the People's Court of Trao-Vinh Province. At the cassation trial, the representative of the Supreme People's Procuracy agreed with the appeal of the Chief Justice of the Supreme People's Court, but requested the trial panel to cancel the first instance and appellate judgments and suspend the settlement of the case because according to Article 1, Resolution number 23/2003/QH11 dated November 26, 2006, of the National Assembly, the chairman of the People's Committee of Trao-Vinh Province was not allowed to make a decision to resolve the request of Ms. Hong T.L. Part 4. Assessment of the Court. 1. Regarding the procedures. Decision number 1350/QDUBND dated July 27, 2012 of the Chairman of People's Committee of Trao-Vinh Province on resolving the claim of Ms. Hong T.L. was issued based on the provisions of Article 1 of Resolution 23/2003/QH11 dated November 26, 2003 of the National Assembly on houses and lands managed or arranged by the state for use in the course of implementation of house and land management policies and socialist transformation policies before July 1, 1991. Which stated, the state shall not reconsider the policies and the implementation of the policies on house and land management and the policies on socialist transformation related to houses and land, which had been promulgated before July 1, 1991. The state shall not recognize the reclaim of houses and/or land, which have been managed and arranged by the state for use in the process of implementation of policies on house and land management and the policies on socialist transformation related to houses and land. Decision number 1350/QDUBND dated July 27, 2012 of the Chairman of TRA-VN People's Committee gave rise to, changed, restricted and terminated the legal rights and interests of Ms. Hong T.L. Therefore, according to the provisions of Article 3 and Article 28, Law on Administrative Procedures 2010, Decision number 1350/QDUBND dated July 27, 2012 was an execution decision and was the subject of an administrative lawsuit. Therefore, the first instance court's handling of the case was legal. 2. Regarding the content. 3. The house located on number 05N, Ward 2, City T, TRA-VN Province was originally owned by Ms. L's family. However, on August 21, 1984, the People's Committee People of TRA-VN Town has issued Decision No. 35/QD84 which stated now, managing the whole house and land of Thang Nhat Bedroom, N Street, Ward 2, T-Town owned by Mr. Hong Saar, including the front and the back home fleet, leaving 03 ground rooms of the back home fleet for being used by Hong Saar. In addition, on July 28, 1985, the People's Committee of TRA-VN Town issued Decision No. 59/QD85 which stated the entire of Thang Nhat Bedroom would be managed by TRA-VN Town Industrial Board. In 1988, when Mr. Hong Saar was still alive, he requested the authority to return the house to him. However, in Official Dispatch No. 01/PD88 on January 8, 1988 of the People's Committee of TRA-VN Town and Official Dispatch No. 02/TTND on November 5, 1988 of the People's Committee of Kiew Long Province, they responded not to accept the request of Mr. Hong Saar because the house was under renovation. Disagreeing with the settlement of the People's Committee of Kiew Long Province, Mr. Hong Saar had many complaint letters. After he died, Ms. Hong T.L. continued to complain. 4. In Official Letter No. 358/BXDTTR on February 26, 2007, the Ministry of Construction gave the opinion on Ms. L's complaint. Although the aforementioned house was directly being used by Mr. Hong Saar, but the government had decided to manage this house and actually arranged to use it after the liberation until the family of Mr. Hong Saar appropriated, 1990. Therefore, the Ministry of Construction agreed with the proposal of the People's Committee of TRA-VN Province that Hong Saar's family could sign a contract to rent the house number 05, Street N, which clearly stated that Mr. R's family could buy this house in accordance with Decree No. 61/CP of July 5, 1994 of the government. 5. Thus, by issuing Decision No. 35/QD84 on August 21, 1984 and Decision No. 59/QD85 on July 28, 1985, the People's Committee of TRA-VN Town determined the state has managed and arranged the use of lands in the process of implementing the housing management policies and the socialist renovation of houses and land policies according to Article 1, Resolution number 23/2003/QH11 dated November 26, 2003 of the National Assembly on Housing and Land managed and arranged by the state during the implementation of housing management policies and socialist renovation policies before July 1, 1991. Therefore, Ms. L's request was unacceptable. The chairman of People's Committee of TRA-VN Province issued Decision No. 1350/QDUBND on July 27, 2012 on not accepting Ms. L's request was legal. 6. The court must accept the case for settlement to aim at rejecting the petition under Point A, Clause 2, Article 193, Law on Administrative Procedure in cases the petitioner claims the administrative decisions of the competent agencies, which stated not to accept the request for reclaiming land use rights in houses which the state has decided to manage and arrange the use in the process of implementing of the housing management policies and the socialist revolution policies related to housing before July 1, 1991 according to Article 1 of Resolution No. 23/2003/QH11 dated November 26, 2003 by the National Assembly, and such decisions were issued under the right competence, contents, and procedures. Therefore, in this administrative case, the Court of First Instance rejected the request of Ms. Hong T.L. on cancelling Decision No. 1350/QDUBND dated July 27, 2012 of the Chairman of TRA-VN People's Committee was grounded and lawful. 7. Decision 1350/QDUBND also stated Ms. Hong T.L. is allowed to buy back the house and land use rights at 05 N Street, Group 3, Ward 2, City T, Trao-Vinh Province as prescribed in Decree No. 61/CP of July 5, 1994 of the government. Therefore, Ms. L family's rights and interests would be ensured when she was allowed to buy back the house and the land use rights in accordance with the provisions of Decree No. 61/CP dated July 5, 1994 of the government. 8. The Appellate Court, based on Clause 1, Article 4 of the Decree No. 127/NDCP dated October 10, 2005 of the government, guiding the implementation of Resolution No. 23/2003/QH11 dated November 26, 2003 of the National Assembly and Article 5 of Resolution No. 755/2005/NQUBTVQH11 dated April 2, 2005 of the Standing Committee of the National Assembly to accept Ms. L's appeal request on cancelling Decision No. 1350/QDUBND dated July 17, 2012 of the Chairman of Trao-Vinh People's Committee was wrongful in accordance with the law provisions. 9. The opinion of the representative of the Supreme People's Procuracy at the cassation trial was unacceptable. According to Article 94 of the Law on Organization of People's Councils and People's Committees in 2003 and Article 7 of the Law on Complaints in 2011, the chairman of Trao-Vinh People's Committee issued a decision to settle the complaint of Ms. LUient T was grounded and lawful. Therefore, Part 5. Rules. According to Clause 2 of Article 266, Clause 2 of Article 272 and Clause 2 of Article 274 of the Law on Administrative Procedures, 2015. 1. Accepting the appellation number 05/2018/KNHC on February 23, 2018 of the Chief Justice of the Supreme People's Court. 2. Cancelling the appellate administrative judgment number 175/2016/HCPT dated November 25, 2016 of the Collegial People's Court in Ho Chi Minh City, upholding the first instance administrative judgment number 02/2015/HCST dated January 26, 2015 of the People's Court of Trao-Vinh Province. Content of the case law. 6. The court must accept the case for settlement to aim at rejecting the petition under Point A, Clause 2, Article 193, Law on Administrative Procedure in cases the petitioner claims the administrative decisions of the competent agencies, which stated not to accept the request for reclaiming land use rights in houses which the state has decided to manage and arrange the use in the process of implementing of the housing management policies and the socialist revolution policies related to housing before July 1, 1991 according to Article 1 of Resolution No. 23/2003/QH11 dated November 26, 2003 by the National Assembly, and such decisions were issued under the right competence, contents, and procedures.